Should you have a will or a living trust, and why does it matter? In this video, I'm going to give you a crash course on what the difference is between a will and a trust and why it matters. Let's start with why it matters. Well, we're talking about the distribution of your assets once you've passed away. So why does it matter? Well, it matters because most people, I think, want to make it as easy as possible for their loved ones to distribute their assets when they die. And depending on the documents you have in place, a will or trust or nothing at all will have a huge impact on the experience your family has going through that process. Okay, so the hot topic, a will or a living trust. If you've been watching my videos, or even if you haven't, the debate usually comes down to wanting to avoid probate court. And most people have heard that probate court is something you want to avoid. It's lengthy, it's time consuming, it's expensive, and it's mostly bad. And for the most part, that's true. Simply put, probate court is the court-supervised process that if you die with any assets in your name, the court and the judges need to approve of the transfer of the assets out of your name into the name of your loved ones. The next important point to make here is that a will not avoid probate court. If all you have is a will, your family will go to probate court. A lot of people mistakenly believe that if they have a will, they are taken care of and their family can avoid probate court. That is simply not true. All the will does is tell the judge how to distribute your assets. So why do you want to avoid probate court? Well, if you've watched my videos or you've learned on your own elsewhere, probate court takes roughly 18 months. It usually takes 5% of your gross value estate. So the fair market value of everything you own, take 5% of that, and that goes to court costs, attorney's fees, and all other kind of random fees that go through the court process. Meanwhile, during those 18 months, your family will have no access to your assets, but they will still have to pay the bills to maintain all of your assets. So out of their own pocket, they will be paying to maintain any rental properties or paying property taxes on your residence, continuing to make any other payments that are due on your behalf until the probate judge authorizes an order to your representative that they can have access to your accounts. So to recap, if you have a will or you don't have a will, your family's going to go to probate court and it's going to take a long time. It's going to be expensive. It's going to be public. Your creditors will know who's about to inherit a lot of assets. They will know everything that you own. And really, the only people that come on top are creditors. A living trust is totally different. A living trust effectively avoids probate court. You don't have to go through the 18-month court-supervised process. You get to take the assets proactively out of your name. Your trust owns everything so that when you die, you can seamlessly pass everything that you own to those that you want to have it, when you want them to have it, and they don't need to get frozen out of your assets. They can do everything they need to do to shut down your estate and pay everybody according to your wishes. So it is completely private. It is much less expensive. It is quicker. It is seamless. And if all goes well, it can be wrapped up in way less than 18 months. If you have any follow-up questions, I would love to hear from you. So drop the questions in the comments below and follow my page for more tips for estate planning.